Thank you, everyone. I know there's absolutely nothing better to do at 9 o'clock on Saturday night in New York than come to a talk about patents. I'm an attorney at the Electronic Frontier Foundation. My full title is Senior Staff Attorney and Mark Cuban Chair to Eliminate Stupid Patents. That is actually my job title. Mark Cuban supports our patent work, even though he doesn't agree with everything EFF does. He also thinks there are a lot of stupid patents. We do a variety of things on patent policy. We litigate, we've challenged patents. We challenged a software patent on podcasting that had been used to threaten podcasters, and actually got that patent invalidated. And it ended up going all the way to petitioning an appeal on the Supreme Court, which we won about 3 or 4 weeks ago now. Thank you. We also do regulatory submissions, we blog, and we go to Congress and try and get them to either do good things or not do bad things. And I'll get to some of that towards the end of this talk. But this talk is really going to focus on a series we have, the Stupid Patent of the Month, that we have to highlight problems with software patents. There are a lot of problems with the Patent Office that we will start to get into in more detail. And it's been kind of an educational process. It's good for us to have the discipline to write every week. And we focus on software patents, which is what, because of the sort of digital mission of EFF. But before we get to software patents, I wanted to share with you some of my very favorite stupid patents. So let's go to the method of swinging on a swing. This is not a joke. This is a real patent that issued. Was filed for in 2002. It was filed by the child of a patent a prosecutor who had a kid who was very excited about finding a new way to swing side to side on a regular swing, and helped his kid file this patent application. It was issued. They got a lot of bad press. I mean, really, like, what? Like, it's kind of a silly patent. But not a software patent, but still, you know, what? So this is one of my personal favorites, the user-operated amusement apparatus for kicking the user's buttocks. This was, and you might think, it's amusing, like, hey, this is a real machine. Maybe this isn't that stupid a patent. But I still think, really, no matter how deep into the sort of what of the patent system, that there's always more sort of what to be had. And so I've shown this patent at talks did before, and someone came up to me and said, you know, there's one of these on a road in South Carolina between, you know, some town on the beach. It's like a tourist thing. And I was like, oh, wow, that's interesting. I wonder if it's like the actual patentee. And I looked into it, and it's a machine that this was on the road in New Bern, North Carolina. It's from 1937. And, you know, this is a patent that was issued in 2000. So, you know, there were only 63 years after the machine existed, someone decided to patent it, which, you know, shows that the Patent Office is not always the best at finding prior art. You know, sometimes they allow patents on things that already exist. So this is again a real patent drawing, a patent name. And you may think, well, you know, maybe the claims are a little different. You know, in patent law, the claim at the end of the patent is really the big important thing. This is, you know, maybe it's on a particular kind of brick made to build a pyramid. No, it's really like you read the claims, and there's a bit of patentees and a bit of you know, sort of pretend complexity to it, but it's really a patent on burying human remains in a pyramid. And, you know, if you think the patent system is supposed to be on something new, you know, is anyone in this room aware of prior art on this patent? But, you know, what is the Patent Office doing? Like really, like if you, what was the examiner doing? And that, you know, like I just don't know. Anyway, So turning to our beloved software patents, that we come to the first question, which is, what is a software patent? There's not really a clear definition of what a software patent is. It's certainly not software. Like sometimes you see pseudocode in a software patent, but you very rarely see lines of actual code. Sometimes you'll see like a little snippet here and there, but generally it's like if you're at an organization and you have a problem and you need to solve it with software, and you meet and you say, well, what are we going to do about this? The software patent is the thing that happens in the first 1 minute of that meeting. It's like, well, obviously we're going to need this or that structure, we're going to need a server, and all the hard work. It's just basically do a thing with a computer. So yeah, if you look at software patents, there'll often be flowcharts, there'll be discussions of using a processor and memory and like at that level of generality. And if anyone who actually programs for a living will like, yeah, I do in fact use processors as part of this. This is not particularly inventive to tell me to apply processing and memory to solve a problem with software. So why do we care about software patents? Like when the sort of my opposite numbers, the people who argue vehemently in favor of software patents, so the kind of people from companies like IBM or the intellectual property owners organization, when they talk about patents, they'll say, well, if there are no patents, then anyone can just steal your work, and that's terrible, and there'll be no incentive to innovate. And that's not really true, because the patent system is not about copying. Copying is not an element of patent infringement. If you write a program and you release it, and then someone sends you a letter saying, I have a patent on, let me see what's my favorite, on using a computer to send notifications, and your app has notifications, and you've never heard of this person, you've never read this patent, they're completely unknown in the community, they had nothing to do with any of the operating system, hardware, anything to do with your app, that does not matter. It doesn't matter at all. The question is, do you infringe, which is the patent, there's the claims at the end, that has I claim X, Y, and Z. Do you do X, Y, and Z, and then is the patent valid? And then that's a question of, was it new? And at the patent office, that often means really, did someone else patent it before? Because as we'll talk about in more detail as we discuss some of these patents, the patent office is not great at looking at prior art, which is stuff that happened before you applied. Prior art can be written, it can be publications, but it can also be things that are on sale. So anything that's in the App Store, on GitHub, and some kind of open source project, whatever, if it's available publicly, it's prior art. But very, very little of that prior art is getting through, filtering in any meaningful way to the patent office. And so you get these patents where they're really broad, they're from people who didn't contribute in any meaningful way to what's being done in the real world, and they're being asserted against people who are contributors, are writing original software. And in this sense, it's very different from copyright. Copyright, there are debates and questions about how broad copyright should be on software. We can talk about Google v. Oracle and APIs and reverse engineering. There's issues, but at the end of the day, like if you copy a huge amount of code, you're probably infringing someone's copyright, and it's right there in the name of the legal right, copying. And if you do it with permission, and that permission may be a software license, particularly like in the free license world, you get something, it's a free software project, you fork it, you contribute to it, whatever, you're operating within this zone of permission and creativity, and you can't be then sued by the person who wrote the kernel or whatever 10 years ago because they've licensed it to the world under these terms. The problem with patents is someone comes in from outside who has nothing to do with anything, with a piece of paper, and says, all right, now you owe me money. Now you can't do what you want to do. So let's get to some stupid patents. Don't worry too much about reading the little text, but we had one of our very first stupid patents of the month was from a patent assertion entity called Blue Spike that has a number of patents. Basically, they're on fingerprinting. And they've been very active. They've sued a number of companies with mixed success. The patent that was the subject of this article eventually got invalidated, and that was upheld on appeal. But they still have other patents in the family and other patents, and they're still actually suing companies. And they were very salty about this article. I got a lot of hate on Twitter from friends of the inventor who were extremely outraged that someone would critique this brilliant genius. Who suggested that using reference generators, feature selectors, comparing devices, and recorders, you could do it with software. You could do it with hardware. You could do it, I don't know, with water molecules, but you could do it with software. So now he owns this idea in his mind for thing. And this kind of highlights a recurring problem with software patents in that the system. Software patents often involve claims that are very, very functional. It's like, do a thing with a computer, have a comparing device or notifications or whatever. And there's sort of the patent office doesn't really have a good sense of what's amazingly easy and what's hard. And so they'll give patents that kind of have both problems in that you'll get a patent on something that's just mind-numbingly mundane. Sending in a second, we'll get to a out-of-office email patent. And then you'll get patents on quite challenging things, but the patent doesn't actually tell you how to do it. It just says, use a bunch of structures, use some memory, use a processor, and do it with software, and good luck to you. And so people are claiming broadly, they're claiming really, really obvious ideas, they're claiming broadly, they're claiming basically the solution. This is the problem with software patents, particularly as people get to claim they claim the problem rather than the solution. Rather than this is how I'm going to solve it this particular way, they're solving this problem X with software is my patent. And that. So another one we did, we wrote up. When was this? This was early last year. IBM patent. I found this just trolling the Gazette. So every Tuesday, there are about 300,000 patents issued every year. So if you check, I think it's about 6,000 a week get issued, something like that. We find stupid patents of the month in a variety of ways. We look to things that are being asserted in trolling campaigns. We look for, people send them to us by email. But sometimes I just go and read the Gazette. It comes out every Tuesday. If you know the classification system, you can kind of know where the garbage tends to cluster. And I'll just go and spend, a morning clicking through 200 or 300 patents to find something really dumb and make fun of IBM. So I just found the Gazette. It's the title is out of office email, and the patent. In fairness to IBM, so this was issued last year. I wrote about it right after it was issued. In fairness to IBM, it wasn't just the idea of out-of-office email. There was a little tweak, and the tweak was that you could set up your out-of-office email so that it would start sending the message a couple of days before you went on vacation. So it would say, I will be out of the office next week. If this is a major project, wait till maybe you can wait, or whatever you want. But from a technical perspective, this is not inventive. This is just clicking, this is just adjusting settings in software that, if it doesn't already exist, is extremely mundane and extremely easy to write. I often give the example that if you invented a car, you wouldn't give someone a patent for the idea of driving the car before 8 a.m. on Sunday, because obviously you can drive a car at 8, like that. Well, that's just ridiculous. But you do see software patents that are basically like that. They're like, one of our stupid patents of the month, it's not up in this presentation, but it's on updating computer game software to update, like if you have a game that's like the NFL or whatever, and a stadium changes, maybe a team moves stadium, you update the game so that the graphics of the stadium is new. And it's just a patent on updating software. Like there's nothing in the patent that solves any new technical problems. It's just like people have been updating software, and over the internet, of course. People have been updating software over the internet for a little while now, but this is a patent that was issued 2 or 3 years ago, and it was asserted. EA got sued, and a bunch of other companies got sued with it. And so one of the big problems here is like you're thinking, well, out of office email, have I heard it? Does that ring a bell? Is it something that exists? Here is a drawing from the patent, and this is, the patent was filed, I forget the priority date, but it's recent. It's like a 2010s patent application. And, this is a 1998 screen cap from Notes. Like, you think maybe the examiner should be looking, if we assume that software patents are a thing that should exist, that the examiner should at least look at some software. But this patent was examined, and on a patent they'll show there's a list of references considered by the examiner. They're all patents. Like you're talking about out-of-office email, and the patent office isn't looking at any software at all. It's only other patents. So this is particularly punishing for the free software world, where people have philosophical objections to patents, so they're not filing them. It's like a $40,000, filing a patent, paying the lawyer, all of that is like a $40,000 project to get it in, and that's a really expensive way to create prior art. It's not prior art. If you publish it online, you put it on GitHub or whatever, that's prior art. But the patent office will only look at it if it's a patent, and you're not going to spend 40 grand to file a patent in the hope that one day some examiner is going to look at it. Fortunately, IBM was sufficiently shamed by the media coverage of this patent that they actually disclaimed it, which I was quite surprised by. I would have thought they would just ignore us. I mean, that's what I would do if I was their PR person. But which means they file a form with the patent office that says this is now dedicated to the public. So I can give you all the good news that if you want to write an out-of-office email client that sends the out-of-office email a day or two early, you can now do that without infringing a patent. So that's how IBM reacted. IBM, kind of figured, well, we'll head this off at the pass. We'll accept a little bad press and give the patent to the public. That has unfortunately not been our experience with all of these posts. A lot of the patents we write about are by what are informally called patent trolls, companies that assert patents sort of as their business model. There's no clear definition of patent troll, but in our view, if asserting a patent is your main game, then we think that's pretty trolly. But the problem with patent trolls is, if your main game is litigating, then if you start to see every problem as a litigation problem, and so getting criticism maybe is also a litigation problem. So 2015, we wrote about a company then called Eclipse IP. They changed their name, I suspect, to get out from the Google results. They're now called, what is it? Electronic Technologies LLC. Something extremely mundane, something very hard to Google. And this was a patent on a kind of notification. There are a lot of patents on just little tweaks to notifications, little tweaks to geolocation, like pretty much any kind of thing you do with an app. There's just this huge cluster of patents on any kind of small modification to the feature you can think of. The inventor in this case is a patent lawyer, and that's not uncommon with a lot of trolley patents. There was a guy that sued Twitter for asserting a patent on having a social network, but with famous people. And he later, in full disclosure, my firm represented Twitter in that case. He later, in deposition, admitted he had never written a line of code. He thought of the patent in half an hour, and sort of half an hour's work, social network of famous people. There are famous people on Twitter. Twitter infringes. That went all the way to a jury. The judge didn't grant summary judgment, so without being specific, going to a jury is expensive. It's very, very common in patent litigation that will cost more than $1 million. So someone spends half an hour, a patent lawyer spends half an hour thinking about something, that costs you $1 million. Not super fair in our view. Anyway, turning back to this patent lawyer, we wrote about this case. Eclipse IP had filed a number of lawsuits with this patents in the same family. This was a new patent that issued from the family that had been asserted very widely. And we were annoyed because other patents in the family had been found invalid. And this was under I'm going to talk in more detail about Alice v. CLS Bank, this decision from the Supreme Court that says you can't have an abstract software patent where it's an abstract idea on a generic computer. Came down in 2014, has been really good for a lot of these really, really low value software patents have been thrown out. And we were concerned that the patent office had issued more patents in the same family, even though others were being thrown out. They hadn't disclosed this to the patent office at the time. We called them out, but didn't, it started to get interesting after that. So the inventor, the lawyer, Scott Hostemeyer, sued me personally, sued EFF, and I was pretty mad. His lawyer's name was Sanford Asman, goes by Sandy, and he had already been in the news for a trademark threat against a startup, and Ars Technica people had been kind of getting stuck into him on the comments, and I will fully admit that these comments were pretty immature. Sandy Asman, people had been modifying that very slightly. But we fortunately found a law firm that represented us for free, and we sent them a very detailed letter explaining that our speech was protected by the First Amendment. One of the disputes was they were very upset that we had complained that the Patent Office hadn't been told about this court decision, and they were like, there is no ethical duty to tell the Patent Office about a court decision. This ethical duty to disclose prior art that only applies to actual prior art like journal articles and so on, but the actual Manual for Patent Examination and Procedure and Federal Circuit law is extremely clear. Like there are decisions directly